we have I think, a really superb panel this morning. My name is Bob Schwartz. I was a founder and ran Juvenile Law Center that's based in Philadelphia for 40 years until I retired, and worked on the dual status standards that are the backdrop for this morning's panel, and I'll give a little overview of them in a minute. What we're going to do this morning is have presentations, first from Kevin Bethel, to my right, who for almost 30 years was with the Philadelphia Police Department, finishing as a deputy police commissioner in charge of almost everything that happened with the police in Philadelphia, and including the creation of a school diversion project that is, I think, one of the most exciting in the country, and we'll hear about that. He's now the founder and executive director of the Law Enforcement Juvenile Justice Initiative, which he has just launched after completing a fellowship with the Stoneleaf Foundation in Philadelphia after he left the police department. Following Kevin, we'll hear from Katie Weinstein-Miller, who is the Chief of Programs and Initiatives with the San Francisco District Attorney's Office, a position she's held for the last 5 years or so, having also done almost everything at the DA's office in San Francisco, and being very much responsible for excellent diversion work that we're coming out of the prosecutor's office that we'll be talking about. I'll fill in with a brief sort of sorbet around some of the defense work that can go into implementing these standards. And we'll be finishing with Judge Steve Teske, who's the chief presiding judge in Clayton County, Georgia, and who is probably more than any other person in the country responsible for changing judicial attitudes on school referrals and reducing them, but not only in his county, but across the U.S. In many jurisdictions. So each panelist will talk for about 15 minutes. We'll have plenty of time for give and take to hear about both your programs as well as the questions you have about the ones we present on or about the standards themselves. So the American Bar Association 2 years ago adopted as its policy a set of standards, which we call this dual status standards, dual standards youth. The task force committee was chaired by Judge Ernestine Gray, who is sitting down now as we talk. Welcome, Judge. And spent really almost 10 years developing standards that were addressing the fact that the juvenile courts were now dealing with referrals from schools, we're dealing with referrals from foster care, child welfare agencies, residential care, treatment programs, mental health facilities. And the juvenile court was the place of last resort, became the behavior modification arm of treatment programs. It became the disciplinarian for schools and school districts. And the ABA was taking a look at it because that seemed like a not quite appropriate role for juvenile courts to play. So the dual status standards were designed and are designed, and they're in your online programs, and you have apps and access to them, to reduce unnecessary referral to juvenile court. And this involved both diverting youth from juvenile court who shouldn't be there, whose behavior can be better managed by other systems. Because juvenile court's not the only one with responsibility to manage the behavior of children as they grow up. Schools have responsibility to do that, and in particular, those involved with special education students, the IEPs have a behavior management component to them that shouldn't be left to the juvenile court to enforce. So there's a diversion part of it, but there's also in the standards making sure that youth who are in juvenile court appropriately have access to services from other systems and opportunities to get to those other systems in a timely way. And we'll be talking a little bit more about that. So at the core of this is the underlying question: what do we really expect the juvenile court to deliver in terms of services and risk management so that public safety is addressed without doing harm to the kids who come before it? And that's what these standards are about. They're designed to basically reduce the juvenile court's oversight of minor delinquent behavior. And minor delinquent behavior is defined as conduct that does not rise to the level of significant or repeated harm to others, significant or repeated loss or damage, or a threat of significant harm to others. And in fact, there are some jurisdictions around the country now that have started diverting misdemeanor cases from juvenile court and recognizing that the court itself should be reserved for more serious offenders. The standards have general principles. There are 14 of them. I'll just mention a couple that are worth noting. One of them is that child welfare and other youth-serving agencies, such as schools, should not refer a youth for law enforcement intervention for minor delinquent behavior. That's a basic principle. Another is that there should be cross-system cooperation and protocols developed that discourage inappropriate referrals to juvenile court. And you'll be hearing about some of that this morning, in particular, as Judge Teske describes the protocols he developed in Georgia. Another aspect of this is for kids referred from the foster care system, the importance of keeping the cases open and not closing those cases. I know California has gone through a lot of changes in the last 10 years in ways that have tried to get better cooperation between child welfare and juvenile justice. These standards really promote that. So the standards are the backdrop for a lot of interesting stuff that's going on, and we'll begin with the beginning, which is the kids who we saw a huge increase in referrals from schools to juvenile court in the last 20 years, and now we're seeing an effort to push back. And Kevin Bethel will describe his work in Philadelphia at pushing back.
So good morning, everyone. First, I want to thank Bob and ABA for giving me the opportunity to come out and speak to you. But before I start, it's like trying to do a program that I usually talk about in 4 hours and 15 minutes, like speed dating. So I will move pretty quick, but I don't go to any forum, particularly when I'm in the presence of Judge Teske, without acknowledging him. I would not be sitting here had it not been for him. His leadership, I'm sitting on a panel. If I take back, 6 or 7 years ago, I'm sitting on a panel, and I'm in law enforcement. I'm a deputy commissioner in Philadelphia Police Department. I'm asked to be a part of this juvenile program, national juvenile program out of IACP and MacArthur. And I'm in the room, I'm like, what the hell am I doing here? What is this all about? What are they talking about? And this Southern judge kept nudging me and kept nudging me. I'm getting exposed to all this training, trauma training, and at some point, at the same time he's nudging, my light bulb goes on. I reached out to him. He gave me everything he had in his toolbox. And so a lot of what you see here today is because of his leadership. So when you talk about where judges and others can play a critical role in how particularly law enforcement can move in this direction, he is a shining example of that. And so let me really quickly talk about, so just let me back up for a minute, just to preface. I'm a deputy commissioner of the Philadelphia Police Department. I run all the patrols for the city of Philadelphia. I oversaw the school police in 2012, 13, 14, and then I'm in this space. After I've talked to the judge, I've really had my light bulb go on. I go and pull the data on the number of kids we're arresting in schools, and I said, you got to be kidding me. For those in the room, I know I probably by this time I'm running up and down the hallway, so sitting at this table is really hard for me. I usually like to be out walking, but I sat there one day looking at the data, and I said, I can't believe that I'm locking up these children for these things. I sat down and looked at a piece of paper. I'm born and raised in the city of Philadelphia, went to public school. I went to elementary Catholic school, and then for those in the room, when you got in trouble in Catholic school, the nun said go to the 3rd floor, and she had the yardstick, and the biggest nun in the building gave you a few whacks and you went up. Now, I'm not bringing back corporal punishment, don't get me wrong, but that was just the reality, right? And so I was shocked And when I dug deeper to realize that we were just putting these kids into the system, and 85% of those kids were being diverted the next day on the post side. It would become a challenge for me to understand why I was even traumatizing a 10-year-old child who would come into school, who may have gotten bullied the day before and put a butter knife in his or her pocket. We were fingerprinting them, taking them into custody, fingerprinting them, photographing them, hold them in custody for 6 hours, for the next one say, you know what, I don't know why you're bringing me these kids. And so what I will share with you was what I came out of that environment saying I couldn't do it anymore. And from coming from a law enforcement perspective, one of the things the judge taught me, he says, Kevin, listen, as a law enforcement leader, you can lead in these areas too. And I was not going to throw this on the judges anymore or prosecutors anymore. I walked into the room and Commissioner Ramsey, who was the police commissioner at the time, Commissioner Ross, who's the president police commissioner, I said, I can't do it anymore. Well, what do you mean you can't do it anymore? I can't sit there and run a police department that locks up children for these minor offenses. It's unacceptable as an department, and they told me, okay. So for those in the room, when I walked out the door, it was a done deal. Yeah, we were going to change how we would forever deal with young people, particularly how they came into school setting. And so how did we do that? I mean, we had zero tolerance policies. We had metal detectors in our schools, but we had metal detectors well before any of the activity that's happening across the country, more because we had 2 shootings in the early 90s. A student was shot in one of our schools, and a teacher was shot. So there was a decision to put metal detectors in all of our schools in the early 90s by the president superintendent at that time. But with that came 320 school officers. Quickly set this up. We have school officers who are security officers. They're not sworn. They do not carry guns, but they do everything a police officer would do in that building, other than they just don't have a gun. They have handcuffs. They make the arrests. And we support them with 85 sworn officers who will come to the school and finish off the arrest process. So security officer sees a fight, they lock up the kids for a fight, they call the sworn police officers, they come, take that case, and they will go ahead and arrest that kid and process them. And so we had disciplinary, it was off the chart, that had changed significantly. Dr. Height, who's the superintendent now, made some conscious decisions that he was going to move away from suspension, so that has changed. But as I indicated before, 1,600 kids were being arrested in the school district of Philadelphia. The majority of those kids were African-American students, the majority of them. We have Latinos, but Latino students were being, pretty much at their numeric demographics, but the majority of the kids are African-American and Latino youth. We have a large system, 8th largest school district in the nation, 218 schools, 134,000 students. We have another 60,000 students in the charter schools, but we don't have much contact with our charter schools because when the kids get in trouble, they just toss them out. And they send them back to the school system. So they come, they bargain it out of the process. We won't arrest you, but you're going to be expelled from our system. As I told you, we had 84 sworn officers who support and who run this program. We would create a collaboration because, as I indicated, my frustration is, I want to now create what would be a pre-arrest diversion program. And so I want to now say, listen, if you're 85% of the kids that we're arresting every day are being diverted the next day, so they finish the processing, 6 hours, next day they show up at the intake center at our youth center, and they tell them that, hey, we're going to send you to the youth aid panel, where if you stay out of trouble, you complete your youth aid panel model, stay out of trouble for 3 months, you get your record expunged. And so for me, I'm like, well, that to me made no sense that we would go through that process that I indicated before. So I would walk, but I had a different mantra when I did our MOU. I already have what I want to do. And I don't sit up here and say that out of arrogance. So I don't want to come off like this. I'm this arrogant deputy commissioner who's sitting up there. But I make policy and I implement policy. So I'm in a great position to say I can make change. I just need help doing it. And so I would humble myself and walk into these environments and say, listen, I need help. And so as you see around this model, family court, Judge Kevin Doherty, who's administrative judge, I go to him and he supports me. The DA's office, I fought with my DA in a room. I said, I don't want to lock up the kids. He says, well, what do you want to do? I said, I don't want to lock up the kids. He said, well, don't lock them up. I said, so I'm just arguing with him the whole time. He said, well, you don't have to lock them up. I go back to my office and finally my ears cleared up and he said, you don't have to arrest them. And you keep talking about what can we do? Because in our system, we submit charges to our DA for final, for the final charging. And he was like, Kevin, if you don't give them to me, I don't have them. Oh, okay. Finally, the light bulb would go on, right? And so I would engage the public defender because I wanted them in that space because they knew a lot of the back-end issues were happening with young people that I wasn't aware of. And so going around there, and I would bring Judicial University, and you see their logo on my stuff because I wanted to have research attached to what I was doing. Because at the end of the day, I figured if it does go good, they're not going to believe me as a cop. But also I wanted to inform the nation as to the work that could be done if we arrest and if we didn't arrest kids. And finally, I led Department of Human Service, DHS. In our system, the county DHS provides all the services for youth who are in the criminal justice system. They fund all of that. And they would come to me, I would walk up to them and say, I want to do a different diversion model, but I need programming. And they would offer those programs to me. The same programs that a judge would able to divert a kid to, they would give it to me from a police process. So what does that look like? Our diversion originally, as I indicated, we would come into the school would tell us they want to lock up a kid for fighting. We would make the arrest, no questions asked. This is our matrix, that was it. We would change that. In my conversation with Judge Teske, he says, Kev, he had a great conversation, he says, Kev, you don't have to go for it all. Just go for some of the small stuff, some of the low stuff that folks were, but our low stuff was representing almost 75% of all our arrests. And so we would make a determination that we're not going to lock up for fights. 600 fights a year we're locking up kids for. We're not going to lock up kids for coming in school with a weapon, not a gun. But when I have 50 African-American females who get locked up over 2 years for coming in school with mace, and no one ever asked them why they carried a mace. And then guess what? We had a conversation, why you carried a mace, only to find out that it is for protection, which we all knew, because when you asked the school district when the last time you had a mace deployment in school, no one had a record of it. And so we would delineate what those offenses are, serious offenses, so you can't go and beat a teacher. We don't allow that. So those offenses, if you had a prior, you're not allowed to go on our program. The majority of my kids have never been arrested. So we really went after the summaries and misdemeanors. But we also created an intake center. We didn't want young people, 5 minutes, I did 15 already. That's crazy. So I'm going to finish this and not get to my other slides. But no, it's fine. It's fine. But we created a center where we have young people. When they come in, we didn't want to eliminate the bias. The officers, when they get to the school, they have to call into the intake center to get permission to divert that youth. This way, we eliminate anyone. He doesn't smile on me today. I don't like him. He's not on the football team. The priority one, what is the offense? If it fits into our MOU and he has no priors, that kid is diverted. And so we, again, talked about no priors. One of the things I asked DHS was to include, to go and do home visits. Being in the police department for 30 years, I spent a good portion of my time in narcotics. I've been knocked down on quite a few doors and know what was behind the doors. And so I wanted the Department of Human Services and social workers to get into those homes to see what they are. And for all of you in this room, you know what we found. The level of poverty, I used to think I was poor before I came on the job until I came in the police department, but the level of poverty we find in these homes is off the chart. And so we're able to provide those support. We refer those kids to a program that begins the diversion process. And one of the key things here is that we don't go back and make a rearrest either. I am not going back because a kid was diverted for fighting in school to when they don't complete the program, we go back and we go and arrest the kid for disorderly conduct. They get one shot at the apple. We give them a collateral consequences. But the reality from our research, the kids who don't engage in the program are doing just as well as the kids who do. So sometimes it's just, as Judge says, you say, hold your hand out, smack me on my hand, don't do that again, and we keep on moving.
So those programs are voluntary?
Yes, those programs are voluntary. We'll save that for the question. You cut into my 5 minutes. You give me 5 minutes back.
I know.
Just
well,
for that.
You have another 30 seconds.
No, I got 30 seconds. No, give me 1 minute. No,
just kidding.
But one of the things we would definitely understand is just a level of trauma that our young people were experiencing. For us as law enforcement, we get rid of our empathy sometimes, and we just get into this focus like everything is just down the same pipe. The hardest part was to recognize that most of our kids coming to school district were in poverty. Most of them have all these, I don't want to read them to you, but had that childhood trauma. Just if I took a map today and showed you just the sheer violence we have in Philadelphia, and they walk through that toxic stress every day. And for us not to understand that they are coming to that environment like that was crazy. And so part of that was changing. So I'll skip forward real quickly and just share with you the stats, as I finish my 2 minutes. But one thing with policy change is many of you who are overseers of these processes and policy, we went from a system that was doing 1,580. The blue represents the kids who have been diverted. And the teal represents the kids that we are arresting today, 450. This past school year, we're down to 250 kids who are being arrested. So a system that used to do 1,600 kids is now arresting kids, 250 kids a year this past year. Again, moving policy, and no incidents have increased in the school. And then you look at the areas where we've had significant reductions across the board for those offenses that we're not offending for. And even when we came to assault on police, we put out a policy to stop officers from going to the classroom for code of conduct issues. Because when they went in the classroom, what turned into something simple turned into assault. And real quickly, just share with you the recidivism rate. At this point, we're tracking all of our kids. The red represents the kids who were arrested the prior year. They're recidivating at 27%. The kids who were diverted are recidivating at 14%. But one of the clear things is 86% of those kids were never arrested. So in the past, we would arrest them all. So none of those kids are getting arrested, and the ones that are getting arrested, they're coming back at 14%. And I'll end with, Malik is one of my guys who represents the reason we do this program. He said, I didn't want to get put away. You can't come back from that. You've got a record. People look at you different. The police school diversion program, the counsels I had were awesome. They wanted to see us succeed. Malik is doing phenomenally well, wanted to go to college, unable to do that, but has his high school degree, no criminal record, is working 2 jobs, and doing phenomenally well. And so part of that goal was to get those young people into that second process, and give them a second chance so they can move on. I'll stop there, and then I'll come back with questions at the end.
Okay, just one question as a follow-up. So okay. What is your new organization doing now then?
So part of what my passion was really take me to another level, and I created the Law Enforcement Juvenile Justice Institute, and the goal of that is to really, I travel around the country, the bookends to so many things. People invite me to everything because they can't get the cops to engage in what they're doing. And so I said, well, you know what, maybe I should take the lead and engage the law enforcement men and women across the country to support them and try to work with them to give them a better understanding that we can go down this space. We can do both things. We can do policing, but at the same time, we can do this type of work to give kids another chance. As ironically, in 1972, I pulled some data from the police department, and we used to have a program where we did divert young people, 3,000 a year. The police department even made their own risk assessment tool to do that. But somehow over the years with the conversation around super predator and all those other things, we kind of put it off to the side, threw it in a box, and never pull it out. So what we're doing is not new. It's just trying to re-engage our law enforcement folks. So that's my goal, is to really training and really to support the work across the nation.
So if folks want your services, they can reach out to you and
Yes,
work
sir.
with their locals. Okay, that's pretty exciting. And just a parenthesis on this, that the dual status standards in Section 3 have a large section on schools, and the basic premise of it is that the primary authority responsible for school climate, discipline, and school safety is the school principal. The standards themselves try to capture a lot of what Kevin has done, because he was clearly a help to the work of our standards, dual status standards committee, as we were doing our work. And there's also diversion going on right here in San Francisco, and Katie Weinstein-Miller will tell us about it.
Okay, thank you. Thanks everybody for coming to San Francisco. Hope you have a great time here. As Bob said, I'm Katie Miller. I'm the Chief of Programs and Initiatives in the DA's office. That's a really weird title. Nobody ever knows what it means. But what it means for our purposes is it includes all the work that represents the alternatives to traditional prosecution that the DA's office does here in San Francisco. And it also includes our juvenile unit. And I think that is a really good marriage, because I think our juvenile unit should always be about thinking about doing things in alternative ways. I'm going to talk a little bit about, as Bob said, the different ways we do youth diversion here in the city, and then briefly at the end about some work we're doing around data coordination, which I think also dovetails really nicely with the standards. Let's see if I can do this right. Okay. So I know we only have 15 minutes, and I don't trust that we actually are getting 15 minutes, because that felt like 5 minutes. So I'm going to be really quick and say, we're going to start in 1997. For 5 seconds, to say that really a couple decades ago, we were very much in the place that I think Kevin just alluded to. Everybody was talking about super predators and this feeling that we were going to be inundated with kids coming into our system. Our juvenile hall was overcrowded, kids were sleeping on the floor, and the city really decided it was time to do a real overhaul of our juvenile justice system. And the mayor's office at that time partnered with Delancey Street Foundation, which is actually a community-based organization for adults, that's all adults helping each other change their lives. And so he really turned to community for solutions and what we should do differently for our kids. And it led to this whole new way that we envisioned our system, which is called the circle of care. You don't need to look at everything that's on that graphic up there. It's funny to me because we thought that was like the most advanced graphic ever in 1997. But the idea of it has really stayed with us, and the idea was that we needed to have multiple points all along our system where kids were always being connected out to the services that they needed, from earliest identification, maybe before they ever got in trouble, that we needed to wrap our arms around them in one way. At their first point of contact, how could we wrap our arms around them, and all the way through. And the principles that underlie this circle of care, that it is very strength-based for kids, relies heavily on our community partners, and that most of our kids were going to be on the left side of that circle, at home being served in community, and that a very small number would be out of home. So that was in 1997, and what we saw over the last 2 decades in San Francisco, and I absolutely know that these stats are not unique to San Francisco, but we saw this incredible decline in juvenile arrests and in bookings in our juvenile hall. So over that time period, we saw a 74% decline in both. And what I want to say is significant about that is that as the arrests went down, the kids that were still being arrested actually represented a more serious cohort of cases, right? So police really stopped arresting a lot of the lower level cases. So more and more cases coming to us were for felonies and serious and violent felonies. And so I think that the fact that our juvenile hall population decline tracked that arrest decline is really significant, because it showed that even for kids coming in for more serious things, we weren't using our juvenile hall as the solution. And this isn't part of our presentation, but I'll note that our Board of Supervisors a month ago passed a resolution to close our juvenile hall by the end of 2021, which we're just starting to work on as a city, which is going to be a really interesting ride. The other thing I want to note about the data from this time period is the way we started using diversion. And diversion at different points, and I'll talk about those points. But if you look all the way back to 1999, the gray part of that circle represents the cases that we prosecuted business as usual. And in California, I should note that in the way our system works, the police bring cases to probation, and probation brings them to the DA's office for prosecution. So all those gray cases represented arrests where probation brought the cases to our office for prosecution, and then that little blue chunk was where probation on its own would do informal probation diversion for kids. Fast forward to 2017, and you can see that a significant number of cases now in the city are being handled by different kinds of diversion programs that I'll touch on briefly. And what I think is more important is this graph. This graphic makes it look like that we have the same number of cases in both time periods, but we really don't. It looks like that, right? So what we see is that we have many fewer cases than we used to have, and with even the ones that still come to us, we're increasingly using diversion instead of prosecution to handle those. So the first thing I want to talk about is CARC. CARC is our police diversion. And in essence, what it means is that if you get arrested, if a kid gets arrested for a misdemeanor offense in San Francisco, by and large, they will never see any part of our justice system. So at the point of arrest, we have a standing general order for our police department, and they contact CARC, our Community Assessment and Resource Center. There is probation on site there, and they speak to that PO, and the PO instructs them on whether to bring the young person to CARC, or whether they can release them, or whether they need to go to juvenile hall. And almost all misdemeanors, the kids will just be taken to CARC. And it's run by a longstanding community organization in the city, Huckleberry Youth Programs. And it's really designed to hook a child up in that moment with a case manager who will really figure out what their strengths and their needs and their goals and everything they want to do is, and really help them, link them up with services in the city. We initially conceptualized it as a place they would go to get support on their way to maybe also going up to juvenile court. But the reality now, 20 years in, is that most of those kids will never go to court at all. The PO there will kind of informally kind of on a banked caseload, keep those cases at CARC, and their contact will only ever be with a community-based case manager. So you can see from the slide that, we handle a pretty good number of the remaining cases that we have that way. About a quarter of all the arrests, which is basically all of our misdemeanors, the kids just stay there and they never go further into our system. I want to just say, when I talk about arrest, what's not included there. We don't arrest kids and we don't take kids to CARC for status offenses in San Francisco, for truancy or being a runaway, things like that. And there are also, the schools are really not supposed to be sending kids to CARC for low-level offenses. So our school district has what's called the Safe and Supportive Schools Resolution, which the Board of Education passed a few years ago, that requires schools to have mechanisms in place to handle all low-level incidents that happen at school sites. There's a whole response to intervention methodology that our schools have now in place to handle lower-level things. Those should not be the cases that wind up at CARC. And there's also an MOU with our police department in our school district that specifies how police should be on campus. And I'm not the best person to speak about those, but they're important things in our system. And then for the cases that actually do still make it to us, so what it means, the fact that we divert pretty much all of our misdemeanors means that my juvenile unit now, when they're making charging decisions, are almost exclusively looking at felony offenses. And so a few years ago, our office decided that we wanted to find something new to try with some of those cases as well. For a few reasons. One reason was we wanted to keep seeing what we could do differently for kids in the city. The second reason was that as our system has become smaller, our racial and ethnic disparities have become worse, and we felt a real obligation to try to keep addressing that. San Francisco is 5.5% African American, and over half of the kids referred to our justice system are African American. So the disparity is horrendous here. And we really wanted to see what we could do differently with the kids who were still coming to us on felony cases. So we partnered with some experts in restorative justice and community partners to start what we called Make It Right. Make It Right is an opportunity for young people. It's voluntary. In lieu of having their case prosecuted, to sit down with the person that they harmed in a facilitated restorative circle, to collectively develop a plan to address the harm that they caused, and to receive case management support while they're doing that plan so that they can be successful. And if they succeed, we never charge their case. So we've been doing that for about 5 years. It's a small program, but it's for a kind of set range of felony offenses that still cross our desk. And we've seen really amazing differences for recidivism between the kids who go to Make It Right and the kids who go through the traditional process. So about 13% of the kids who complete Make It Right have caught a new case within 2 years, compared to 53% of the kids, similarly situated kids who went through traditional prosecution. And I will say that for the first few years we've been doing the program, we've actually been using random assignment to figure out, to offer it to some kids and not to others as part of a really robust evaluation model. So when I give you those numbers, those are literally randomly assigned kids with a 13% recidivism rate and a 53% recidivism rate for the kids who went through the traditional system. So that's enabled us to now start sending more serious kinds of felonies into that program. And then the last thing I want to note is around our system is court diversion. So even, and there's so many numbers on this, and like you don't need to look at them. One of my colleagues this week said she went to law school because she doesn't like math. So you don't have any obligation to look, but I like math. And I'll say that one thing I want to emphasize from all this data is that what we continue to see in our system, even as the numbers of kids that go before the court go down, is that the court now is overwhelmingly using its own informal probation as a way to resolve a lot of its cases. So even in cases where a petition can be sustained in juvenile court, instead of using out-of-home placement or even formal probation, the court's trying to do something different. So we're kind of seeing these moves out at all different parts of our system. And then the last thing I want to briefly talk about is San Francisco's shared youth database. So this is an effort that's been going on for a number of years in the city. It is a shared database between our juvenile probation department, our child protective services, our Department of Public Health, and our school district to jointly share with each other just basic information about which families they're working with. so that they can better coordinate and wrap their hands around families in productive ways, not create redundant or consistent case plans for the kids that they're working with, and really know when kind of something's hitting a crisis. But when I say share information, all they literally get from this system by design is just a basic alert that another system is now working with that child and the contact person at that department. So they're not actually exchanging information online or through the system. It's taken a number of years to build a data sharing system that complies with all of the laws around, FERPA, so education law, HIPAA, health law, juvenile justice, all of our provisions in our welfare institutions code. It's been a very complicated ride. But I think in the end, what they've come up with is a system that really follows the goal, the purposes, and kind of the standards set forth by the ABA. And they're just now starting to pilot that this fall among those 4 agencies for a group of kids, so that as kids are hitting multiple agencies, the folks working with them in those agencies can know that and can figure out how to do a better job for those families collectively. So I just wanted to share that as another thing that's happening here in the city. And I'm happy to answer questions about any of these things later on. Thank you.
Okay, very good. Just one question while we get help in setting up Steve's thing, which would be that maybe? Does that look like him? Yes, okay, that's pretty good. This is, you're a career prosecutor, have been a career prosecutor, and how have your colleagues adapted to changes that result in fewer cases coming to them?
Yeah, I think it's funny. And I will say I'm really not a career prosecutor. I've been in the office for 12 years, which is like so amazing to me. But my work came through kind of starting some of these programs along the way and then being in DA's office. So I've had the privilege of being in an office, seeing what it's like for people doing the work every day, having started a lot of these programs before I got there. I think a few things. I think for the DAs who continue to do our juvenile work, they don't really touch these programs, right? So it doesn't actually affect their day-to-day, other than they have a lot fewer cases than they used to have. Because the kids who go to CARC never wind up coming to our office. The kids who we divert out at the point of charging never become a case that they actually will be going forward on. So it's resulted in a smaller number of cases. What's made it harder over time is that the cases that still find their way into the system are really more complicated and often serious and violent. And so I think for them, what feels heavier now is that the kind of consistency across their caseload and the circumstances they're working in tend to be much more serious. So whereas previously prosecutors may have had a really big but much more diverse caseload that may have included a lot of low-level, kind of easy-to-resolve cases, that's not the space that they're in anymore. And so I think for them, they feel the weight of often having very challenging cases.
That's so interesting because we've heard from probation staff around the country that many probation officers try to keep the less serious offenders on their caseloads as sort of to cushion the work they do in a sense, because if all they had was serious offenders, it'd be too hard, and they need some easy ones along the way. The prosecutors don't have that option.
Right. What I think has been interesting for some of our really long-time DAs in the office has been that as they see some of these programs, they'll start to say, well, how come, can I send this kid there too, right? So, can I make that be part of what happens? I don't think this case should be in court. Can I just send the kid to CARC and have them get services there? So that's been great to see.
Okay.
But I think it's a process, and I think when DAs hear things like we're going to figure out how to close our juvenile hall and we want to do these other things, I had one of them recently say to me, like, I don't know what I'm supposed to be anymore as a DA in juvenile. Like, what does that mean? How do I even do this right? So I think it's bringing up a lot of questions for them.
Okay, that's good. And for those of you interested in the data sharing component here, the dual status standards have a section sections on data sharing, standards 210 and 211. One is data sharing for policy and system reform efforts, which is aggregate data that agencies can share, and the other is how to share information around individual case decision making that, as Katie described, that involves the protection of privacy, confidentiality issues, doesn't lead to information sharing hurting kids, but information sharing helping kids. And I think the standards are particularly powerful in that regard. So I'm going to talk for just a couple of minutes about opportunities for defense attorneys with these standards, and before turning it to Judge Teske, because the judges have the ultimate power in the room, and they decide these things. So he'll be our closer this morning. The defense portion of the standards, I'd say, are in a way, well, to me at least, the least interesting part of the standards, because they lay out fairly traditional things that defense attorneys have done over the years. We've worked to divert cases, we've worked to get services, we've worked to find other ways to define our clients to the court, to try to get them to see that this is a dependent child, not a delinquent child. It's almost, the Officer Krupke approach, to juvenile defense, in terms of who this child is. And that's sort of codified in the standards, Standard 12 and the 2 pages that govern defense role. But I think that there are opportunities beyond diversion here, although that's really important. In back of these standards is a reminder of the importance of investigation so that you can tell the court or probation who your client is. What do you know about the school records, about the special education background, about the behavior management plan that was supposed to guide the way the school treated your client? To be able to paint a composite picture of your client for the decision maker so diversion is possible are embedded in these standards. The other aspect is, in addition to diverting clients, divert them to where? And diverting to child welfare is an option in some cases, and the standards are clear that that involves a conversation with your client about the pluses and minuses of that. Most of the diversion we're talking about doesn't involve referral to another system for acceptance for services that involve an involuntary status, that leads to the court's control over the child's life. In fact, the whole point of the diversion is to end court control over the child's life. But there are some instances where child welfare involvement is important, and for some delinquent youth, having their status remain in the child welfare system, and the standards call for not closing child welfare cases when the dependency system refers to the delinquency system, but to keep that case open. That's important for the defense attorney to be aware of as well, particularly as kids age out, because the child welfare system offers an opportunity for youth who have been separated from their families, and this may very well involve the more serious cases that we just heard about, to stay in the child welfare system past the age of 18. I mean, California, it was the national leader in extended care, for those of you, who work here, for kids to stay in the system between ages 18 and 21, to have school-based opportunities as well. For states now that receive Title IV-E dollars, which are federal foster care maintenance dollars for delinquent youth, there are also opportunities through the Family First Prevention Services Act for kids to stay in care, but not be in congregate care, which to have services provided in their homes and to have support for kin to take care of them if those opportunities are appropriate. It's not saying that child welfare is a cure for what ails the delinquency system, but these standards recognize that there are pathways out that include the child welfare system, and the defense attorney needs to be aware of that. The other thing that defense attorneys need to do, which is often an unnatural act for many of us, is to work with a dependency attorney, which in some states may not be an attorney, but a guardian ad litem or a CASA. So to be able to work cross systems is another aspect of the defense function, and the standards provide some guidance on that, which is routine probably to many of you here, but not routine across the board. So that I'm not going to do more on the defense function, but I think hearing from Judge Teske and then having your interaction with the panelists is going to be particularly important. So I'll turn it over to you, Judge. Do you have the clicker down there? Has that been passed to you?
I do. I do.
All right, well, then consider that your gavel for the moment, and you're on.
He's not going to give you a 5-minute sign either.
No, he will. Bob will. Before I go into the weeds, ladies and gentlemen, let me start at 35,000 feet and then bring us down to the runway. First of all, the comments of my colleagues preceding me illustrate something that back in 2003, when I convened all the stakeholders in my county, and I'm going to show you a graph in just a moment that explains why I did so. Things were getting out of hand. It was a judicial-led model that came to be. I was influenced by the 8 core strategies of JDAI, Juvenile Detention Alternative Initiatives, of the Annie E. Casey Foundation. And in being influenced that way to approach it using collaboration, it's data-driven, it's alternatives to detention, it's cutting that net down instead of net widening. But being the first school justice partnership in the country, the importance of that is not being first, but we now have a lot of data. We've been doing it since 2003, and it's been studied by researchers much smarter than me who do regression analysis studies on it. In fact, the School Justice Partnership is in a book written by three renowned researchers in community corrections, Mark Lipsey being one of them, and it's titled The Handbook for Evidence-Based Juvenile Justice Systems. Now, I say all of that because I go back to judicial-led. Kevin, Bethel, and Catherine here have proven that this model, in terms of its broad application, and that is to divert youth away from the system, is not just limited to judges in terms of its leadership, but also prosecutors have now, taken up the helm and have anteed up and are doing heavy lifting, just as law enforcement has been doing. And one thing that Kevin didn't share with you, by the way, at least I didn't hear it. I could have been over here too busy tweeting you in your picture there, Kevin. But when he left Chicago at that meeting where he described me nudging, went to his commissioner, and Commissioner Ramsey gave him permission to go to the schools. Well, he went to the schools, and they pretty much shut him down, didn't they, Kevin?
They weren't too open.
They weren't too open. But Kevin, all that did is just piss him off, okay? And so he goes back to the commissioner, and this was one of the things to Kevin that he did give a flip about. And here's the thing. I'm pushing 60 years old, and I've realized there's only a few things I need to give a flip about because I spent most of my life giving a flip about too much that was just wasting my time. But when you give a flip about something that's really important, and kids are important, you begin to stop giving a flip about what people think. And that's my mantra, folks, for the rest of my life. And that was Kevin's. And so he said, you know what, schools, you don't want to participate in it. You know what, you don't get to tell my police who to arrest and not to arrest. And we forget that. So that's what Kevin did. And prosecutors are doing the same thing. Why am I wasting my time on these misdemeanor type cases, minor cases, when I have more complex evidentiary cases that if I don't prove beyond a reasonable doubt, that's going to compromise public safety? And so it's about being smart. Now, having said that, and I want to acknowledge Judge Ernestine Gray over here, okay, who's one of my mentors and is a leader among the judges in this country, and she is also one of the judicially led leaders in this country of the School Justice Partnership down in New Orleans. Good to see you, Judge Gray. All right, let's go ahead. Let's go ahead and, I got the clicker.
You got it, right.
Okay. Now look at this. Okay, so this graph represents what was happening up to the point that I brought all the stakeholders together. What this represents is when we created the School Resource Officer Division and placed SROs on campus in middle school and high schools, all right, our referrals to the court went from 49 the year before to 1,400 by 2003. That's about a 1,200% increase. That also represents 1/3 of the delinquent filings in my court were coming from the school system. It also, that red line, those are misdemeanors. That represents 92% of all the filings, okay? So I think that's important. Now, at the same time this was happening, our graduation rates were falling to an all-time low of 58%. Because we know now from the Gary Sweeten study that came out in 2006 that kids who are arrested on campus are twice as likely to drop out of school. And if they appear in court, they're 4 times likely to drop out of school. I mean, who'd ever think keeping kids in school would increase graduation rates, right? Okay? So, what the School Justice Partnership is, and this is its textbook definition, but really it's a group of stakeholders consisting primarily of representatives from the school system, law enforcement, and the juvenile court, and are assisted by other stakeholders who are involved in the juvenile justice providing legal, social, mental health, or volunteer services who meet periodically to manage and sustain a process guided by an inter-branch agreement designed to promote school climate as well as school and public safety using evidence-based practices that include the reduction of unnecessary referrals to the juvenile court by using in lieu thereof restorative and educational practices and tools and clinical responses if needed. So what we do, the Annie Casey Foundation gives me a $50,000 travel budget. This started in 2006. I have a 5-member technical assistance team. As a result of that, the School Justice Partnership model has been replicated in 41 states and multiple jurisdictions in 41 states. I just finished 3 counties in Indiana on July 24th. And I returned home yesterday from Northwest Ohio, where I worked with 4 counties, okay? So this is a pretty contagious thing. These things that we're talking about here is pretty contagious because it's smart and it's attractive to people who are smart, let's put it that way, okay? But how we do is I develop a toolkit, and Kevin mentioned the toolkit. Now, I'm not going to go through that. You know, you can send me an email, and I'm glad to give you the toolkit. But it methodically takes everyone through identifying what are the most appropriate delinquent acts that should not be referred to the juvenile court, and and it helps the group, the community, figure out what are the appropriate responses in your community, or ones you don't have, you want to get, that you can use in lieu thereof. So it consists of some algorithms and matrices, okay? And we spend 2 days in the communities helping them to do that. Now, what's happened in Clayton County Census is that our school referrals are down 95%, okay? Misdemeanors are now, all misdemeanors are not referred to the juvenile court presumptively, okay? But that's because over the years we've evolved. We've been able to, you know, acquire a lot more responses. Now, this all started off with only 4 misdemeanor offenses, but even with those 4, within 6 months, we reduced the number of referrals by 62%, okay? What's, I think, very important is that because we know that zero tolerance policies really adversely affect kids of color, okay? This graph you see here represents that black line there going up is the number of African-American students who were arrested and referred to the juvenile court. Now you see how it's dramatically declined. All right, our African-American population in my county is about 72, 73%, okay? Back then, at the highest peak, that represents this ratio that African-American students were 12 times more likely than their counterpart, white student, to be arrested on the same offense. That's pretty sick, it's pretty abusive. Quite frankly, it's just a disproportionate it can't be explainable except by implicit bias. All right. Now, we also then, as part of this partnership, followed up. The school system changed its culture, went through several revisions of their student code of conduct. They took the JDAI alternatives to detention and applied that model to suspensions and with the help of the juvenile court and my JDI coordinator, who I loaned to them, they developed alternatives to suspension. So they have now knocked off a lot of these infractions that are eligible or subject to out-of-school suspension. As I come down to the runway here, I want to point out some things that Kevin was talking about and Catherine about. If you take you can't see where you are in the very left, but that's the 2011, 2012. That represents 420, that green bar is 420 kids that instead of being arrested, they were referred to a restorative practice or an educational program. Now, there were a lot more kids that were not arrested, but they were treated with an admonishment, a warning, things of that nature. The officer didn't believe that it was necessary to go through the trouble of a program, okay? But before we did the school justice partnership, all 420 kids were handcuffed. Yet, if you look at what follows, those are the repeaters that year. There were only 55 second time and only, I think, 13 or 14 third time. There were no fourth time repeaters. So it begs the question, why were we handcuffing all those kids in the first place? All right, and I coined a term in an article I published some time ago called hyper-recidivism, and that's when adults, okay, exacerbate a child's circumstances when we criminalize them, when it's not necessary, And lastly, I want to point something out, that even though it doesn't directly deal with a school-to-prison pipeline, but it goes around the research of alternatives to detention, our detention rate, just from the community alone, admissions into our local detention centers down 74%, okay? Our average daily detention population is down 82%. Actually, it's down from a 62 average daily detention population in 2002, our baseline year, to 10.9 today, as of today, okay, in a 60-bed facility. The number of kids that we are now, let's see here, we are now committing to the state of Georgia, removing from their homes on delinquent acts, are down 90%. By focusing on alternatives for deep-in youth, all right? Now, what does that mean? See, a lot of people look at that and they say, my God, Teske, what are you doing down in Clayton County? It must be chaos, okay? You're just slapping kids on the wrist. Well, for God's sakes, you ever thought that maybe a good many of these kids, that's all they need is a slap on the damn wrist, okay? Come on, is anyone home? How would you treat your own kid? All right? So, look at this. Since we started these reforms, including the School Justice Partnership, our delinquent filings are down 82% in Clayton County. As of today, 82%. That's why I can come to San Francisco. I don't have a freaking docket I have to appear anymore, okay? But I mean, don't tell my appointing authority back. I just got reappointed. I think this may be my last term, okay, so I'm going to retire. So, no, you know what? I really don't care anymore, okay? I'm not seeking reappointment. I've survived 4 governors so far. What's more important as I end this thing, I have a couple minutes left, is felonies, folks. If I were to ask a show of hands in here, look at you, lawyers, judges, whatever the case may be, if I were to ask you this simple question, how many of you committed a delinquent act, no matter how minor, when you were a teenager, most of you would raise your hand, okay? But yet, look where you are today. I caused the police and the fire department to come out to my school when I was 13 years old. And if it weren't for the principal who stood up for me, and the police were going to handcuff me. That was 1973. And I wonder if I would be wearing a robe today if I went to detention. And it's really awfully scary. But lastly, so your felonies are down 64%. I mean, our residential burglaries are down 62%. But here's the thing, is graduation rates. Our graduation rates have increased every single year. In fact, in yesterday morning's Atlanta Journal-Constitution, the Metro section, the top story was the success of the Clayton County school system, where it went from being, quite frankly, if there's hell, if there's anything below hell, we were below hell, okay? But that drop, that black line you see right there, let me just explain something, because educators know this. In 2011-12, the federal government, the U.S. Department of Education, changed the graduation reporting formula from overall to on time. On time being, if you start the 9th grade, you only get to count the kids who graduated 4 years later. So everyone's graduation rates fell, like ours fell. But notice that red line, that red line is just to illustrate, regardless of the reporting formula, it kept going up, okay? And so with that said, I just want to end with something that, for the defense attorneys in here who go into the courtroom, look at it this way, as strategies, okay? You know, is the child truly delinquent? Just because a kid commits a delinquent act doesn't necessitate the child is a delinquent child. And you need to be thinking about that if it gets to disposition. But even at adjudication, you need to ask yourself, to what extent does the adolescent brain research, if you're not familiar with it, you need to be familiar with it, is connected, related, and tied to mens rea, criminal intent, the criminal mind. Because if the Supreme Court is already saying this adolescent brain research is relevant in why we should not be sentencing juveniles, you know, kids to life in prison without parole, to what extent on misdemeanor offenses, especially minor offenses, if the adolescent brain research is explaining that that's just typical juvenile behavior, does it not bring to mind, well, if it's just typical adolescent behavior, is it really criminal? You know, and maybe having that discussion in your community could also influence coming up with a different system if you don't have something that's described by the three of us up here. Thank you for your attention.
Okay, good. So I have a couple questions, and I'd like to open it up. And if you have questions for each other, of course, jump in. One, each of you had some level of recidivism in your programs. Whether it was the 14, 15%, 12%, lower than it had been. Have any of those cases come back to bite you in ways that a parolee, or the cases that serve as examples or headlines that scare judges often from making obvious decisions that they don't want it to come back to hurt. So
is that okay if I go first?
Sure. You seem to be jumping out of your seat.
Yeah,
so.
I'm really nervous and excited about that question, Bob. And this was not staged. He did not tell us what questions he was going to ask. But Bob's like that. He likes surprises. So, yes. But I have to say this, that I'm picking this example to make this point. It really wasn't directly connected to the school justice partnership model, indirectly, because this kid at one time had been diverted, okay, was not arrested on campus, okay, but diverted. Unfortunately, he was one of those that kept repeating and eventually committed a felony, though not on campus, but in the community, that brought him into court. In fact, the felony was so serious, it was an automatic transfer, went straight to adult court as armed robbery with a firearm. The district attorney, who is a former juvenile court judge, who believes in all this stuff, she didn't at first. In fact, she tried to sabotage it, but then she realized that her recidivist rates in her court were much higher than mine in my court. She flipped, okay? So she's now the DA. And she transferred the case to my court and wanted to put him in the second chance program, which is the deep end. And I don't have time to explain all that, but it has a success rate of, it's only a 17% recidivist rate. But these are the kids who would have gone to our youth prison in Georgia, which has a 65% recidivist rate, okay? Well, here's the thing. One of the 17%, that kid in particular, that recidivated, though he graduated the program, committed murder, okay? But this is what the DA said, and this is what I want to leave you with. And this is where collaboration and having partnerships in the community are important, where you meet regularly. So you keep yourself informed as to the data, what's working. And with this, she told me, she said, Steve, don't worry, I got your back. You know, you're absolutely right when you keep hitting us with the law of probabilities. If we sensationalize this one outlier case and it works to destroy your second chance program. That means all those 75 kids that have graduated and not committed another crime since 2010 would have gone to prison, and 65% of them would have victimized people in the community. The way I look at this, what you say in the law of probabilities, if we didn't have the program, the question now, would there be more than one that committed murder? Maybe 2, maybe 3. You see, folks, I don't tell people crime is down, felonies are down 64%. I tell them there are 64% fewer victims in this community.
Others, have you had, Katie, a simpler?
So we haven't had anything where there's been any kind of public outcry for Make It Right, for the restorative justice program I described. There have been kids who've gone through CARC, who've been diverted on misdemeanors, who've come back on serious offenses, and a couple of the Make It Right restorative justice kids have too. But I would give the exact same answer as the judge. You know, the 13% versus 53% is a really big difference, and you're always going to have something happen when you're dealing with humans. and I think for me, what's important is when partners come together. So just as a quickie, separate thing, what I'll say is, so in San Francisco, we have a young adult court that we started for 18 to 25-year-olds a few years ago. And we all knew when we started that court, and it's all felony offenses, many serious and violent ones, that we will have that happen. And something like that will happen. And you know, what we agreed from the outset was that we agreed to what our communications response plan is going to be for that, and that it's all the agencies involved standing together, you know, not creating a situation where everybody quietly like scoots back, you know, and leaves the judge or the DA or whoever standing there alone. So I think the hardest challenge for us in San Francisco, when we've had things go sideways after a reform effort of any kind, whether it's bail reform or anything, has been really working with the media to not have them sensationalize that case and that reform effort. And I think that's a bigger challenge for us.
For me, I go into the process already recognize that someone's going to be waiting for something to happen. We're fortunate we did not happen, but I looked at it from a lens of this. Every time I had a police officer killed, the first thing I asked my men and my staff to do was pull their records. And what did I do? Had you kept them in here, the judge had kept them in dead the full 5 years. Had the probation had done what they had done, or had you locked up them, I mean, you're even seeing that in Dayton, in the Dayton mass shooting now, right? The kid was, something happened in high school, you know, I mean, maybe 7 or 8 years ago, and because that was not recorded. I mean, that's what, unfortunately, is the process we're in, right? And so it is that oftentimes, but I think what has helped us particularly is the MOU, particularly for my law enforcement folks. Their biggest fear was if they released a kid who came into school with a knife and he or she came and stabbed somebody the next day, I hold the bag. And so the big part was us to convince them that here's the MOU, that the DA's office, the Defender Association, the judges, all of us agree that this is the right thing to do. So when the event does happen, we stand collectively and accept that as our responsibility and as part of what we all put forth to do. But it can be at times challenging, and it can sometimes stifle, you know, but I always found that folks who live in that space are really not, you know, really moving to make change. It's just going through the status quo, so we keep pushing.
Well, it's the importance of, sinking or swimming together. Your talk, Kevin, reminded me of an experience I had 20 years ago where I went to a local police chief in Pennsylvania, which is, there are 1,200 of them in Pennsylvania because we have a lot of police departments. Everybody likes being a chief, but and I said he was involved with the International Association, and can you do something? I said about not arresting when schools call you to arrest, and he said, no, we're just like plumbers. You know, they call with the problem. We have no choice. But so how have you convinced people now? Do you still get that kind of reaction when you travel around the country? And how are you able to convince them that, as you did in Philadelphia, that they don't have to make an arrest?
Well, I think I said this, say this often. You know, I wasn't trained 36 years ago when I went to the police academy. I wasn't trained to not lock anybody up. I was trained to lock folks up. That was it. I wasn't given you lock folks up and let all those other entities deal with the aftermath of that. And so part of what I say is around training and giving those men and women. I failed the men and women who work for me, who went into a school setting with no other tool other than arrest, recognizing when the school district called them, that's what they were going to rely on, arrest. When I gave those men and women a different tool, how many of you think took it? They all did. I remember in 2014 walking in, doing training for men and women and saying, I'm going to do this program, but I don't have all the elements yet. I walked out that room, that following Monday, I made the mistake of giving them my phone number, and they all are calling me. I got this 10-year-old kid. You said you're going to do this program. Is it ready yet? I mean, they pushed me so hard that we started the program with a notepad, a phone from our IT unit, and a room. Because we failed them, and we in leadership are failing them when we don't give them, those men and women, a tool to be able to make a different decision. And when they were given that opportunity, they were. And so part of that is sharing with my law enforcement colleagues that we have to give them the tools and the training. Where cops are pulling up by your bootstrap. I came out of the community, so you should be able to get out of the community. And so part of that is giving them the training, the developmental training. Real quickly, my daughter, my 15-year-old daughter, is so blessed these days because I go to slide number 16 that says her brain is not fully developed when I get ready to go on TAC mode, right? And I slow down, I close my eyes. She said, what are you doing? Is that slide number 16 again, Dad? Yeah, slide number 16. Because your brain is not developed enough for you to talk to me like that. And so part of that is exposing them to that training as well. That has not been part of our charge and part of our work, and so that's where we've come to that space.
And Katie, as you connect with prosecutors elsewhere in the state, is San Francisco seen as an outlier, as it like the rest of the country portrays it, or do you find prosecutors who say, we can divert these cases too? We don't have to prosecute school cases or child welfare cases. We could divert kids from our system.
I know we always like to think of ourselves as exceptional. We're not. So I would say that the talk about diversion on misdemeanors has changed a lot, right? And I would give as an example Los Angeles, where the Office of Diversion and Reentry down there is now projecting, I think for both adults and kids, but really for kids, that they think they can divert up to 60 to 80% of kids if they start doing things differently. So I think it's caught on a lot. I don't know of a lot of other places that have that CARC model per se, but we get a lot of visits and inquiries and places starting to talk about what they're going to have as kind of a place of diversion for kids. And then the restorative justice model that I talked about, we adapted from our folks from that county across the bay, Alameda County, Oakland. And the organization that we partnered with to do that, Impact Justice, they have a toolkit online now for that restorative justice model, and they are working with 10 jurisdictions across the country, including Philadelphia, to start doing that model there. So I think there's a lot of good replication happening around the space for kids and adults, right? But I like to think, I think it's easier to lead with kids, and to me, it's funny when I look at the trends of kind of system reform over time, I feel like a lot of what we do with young people first eventually makes its way to the adult system, so it's great to get it right here.
And Steve, as you've gone to your 41 states, what kind of pushback have you gotten from judges? Because it does strike me that at the end of the day, judges are a key to the success of any of these diversion programs. If they want it to happen, it can happen, and if they don't, it doesn't.
Well, I have not received any pushback from judges. What I will get from some of the judges is that, quite frankly, they will. I have some judges that will hide behind judicial canons, and in my opinion, they misread them to say, well, I'm going to violate judicial canons. I don't think this is my place to do this. Notwithstanding the fact that the judicial canons promote judges to improve the administration of justice, okay? And how am I not improving the administration of justice if I'm keeping unnecessary cases from coming into my court in the first place, all right? But I don't get into an argument with folks, Instead, I take a different tact, Bob. What I do is I say, okay, I understand that. I appreciate that. I said, but can you at least just be the convener? You don't have to get up and say, you could just say, look, I I'm using my kind of inherent role as a judge because many of you that are going to be in the room, mental health, social services, law enforcement, prosecutors, defense attorneys, there's one place in the entire juvenile justice system, or any system for that matter, in which all those players are going to intersect at one, and that's the juvenile courtroom. And and not to demean judges in this way, but in fact to make a point that kind of makes us the traffic cop. And so in that thinking, I convinced them just to convene. Like Wichita, Kansas, I flew in, met with all 6 judges, had dinner, we cut up, spent most of our time telling jokes, and finally the chief judge says, so I guess we need to get down to business, The question is, my fellow colleagues here want to know, what do you expect from them? I said, I really don't expect much other than y'all just kind of send the invitation out. That's all. And they go, you mean you came all the way up here for that? I said, no, I had a great time with y'all, But let me just say one other thing, okay? What's happened, though, is that the champions in terms of making the request in law enforcement and prosecutors have increased. Macon Bibb County, the elected DA, just 70 miles south of me in Atlanta, okay? Last year, he has now introduced this school justice partnership. We made 2 visits there, one in Peach County, one in Macon Bibb County. He has a 3-county judicial circuit. He has 2 of his counties up and going now. The next one we're going to come in the fall to do Crawford County. What really helps people, I think, is when we had that conversation, you do collaboration, you sign that document, you keep meeting, you have each other's back. The culture begins to change over time, okay? And just keep this in mind, ladies and gentlemen. I remind folks to avoid the Wilt complex. Mm-hmm. You scratch your head. Some of you are now looking up, what the hell is that? The Wilt complex, Wilt Chamberlain, NBA's greatest basketball star, okay, really sucked at the free throw line, okay, 52%. All right, but in 71-72, first game of the season, he gets fouled, he goes up. You remember what he does? The granny shot. Everyone laughed, but he made it. And he continued to do that the rest of the season, and it went up to like 80, 81%. He also in that year scored the most points ever scored in the NBA basketball game, 100 points. But the following year, first game of the season, he gets fouled, and he doesn't do the granny shot. He goes over his head, makes the shot, but doesn't go into the hoop. And it went back down to 52%. Here's the moral of the story. After he retired, a journalist asked him, Mr. Chamberlain, did the granny shot not work for you? He said, oh, it did. Well, why did you give it up? And I'm quoting him because it made me look like a sissy. Well, maybe Wilt Chamberlain can afford that, but we can't when it comes to kids. If you're a judge, a DA, a chief of police, a sheriff, a superintendent, you really need to stop and think about the Wilt complex. What reason are you not doing what works? Is it because it looks soft and you're afraid of it? Well, get over it.
Can I add one thing too?
Yeah, that's good.
We talked a little bit about community.
Because you have a basketball team here in San Francisco, too.
Yes, we do. I wanted to say something about victims for a minute.
Yeah.
So and diversion. So for the restorative justice diversion that we do, again, it's all felony offenses, and it's all cases with identifiable victims, because you can't do a circle without the person that you harmed. And when we started the program 5 years ago, we told ourselves 2 things: that we weren't going to leave it to the victim to decide whether or not the young person was going to get to be offered restorative justice, but that if we ever had a case where a victim really was dead set against it, we would take it back and kind of revisit the question ourselves. And we've been waiting 5 years for the victim who tells us no, right? 5 years for one victim to say, I don't want that kid to have that opportunity. And it's really made an impression on us. I think we were gearing ourselves up for people to be really upset about the idea that that would be the reaction to a young person who may have harmed them in a lot of different ways. We have had victims say that they don't need to be in the circle. Maybe they send a family member. Maybe we find another community volunteer to go in their place, or I should say the nonprofit who does the work finds somebody in their place. We have no part of that circle by design. But we've never had someone say that they feel like that's not the right way to handle the case, and I think that's amazing. And something that we should all keep in mind when we're thinking about what we think community wants.
And it may take less courage than we think. So, questions for any of the panelists, sir?
So do you involve the local media in the program so they understand what's going on and that they don't sensationalize that one problem?
It's a great question.
Yes.
Recidivism, and that can be overblown. In my experience, judges worry to death about that one case where they don't send somebody to jail and they are criticized. And that, I think that's the role of local media to understand the program.
Yes, sir. So in our technical assistance package, in doing this over the years, early on, in speaking to elected officials, those judges who are elected, even if you're appointed, like myself, okay, it can be damaging when that case is sensationalized. It did become very apparent to us based on surveys that we did through our technical assistants in the various jurisdictions across the country. Their concern regarding that. So we included that in there. So what we added in the technical, right up front, in the morning of the first day, when that morning is spent getting everyone on the same page by going through what is a school justice partnership, why do a school justice partnership, what supports the school justice partnership, who's involved, all that W stuff, okay? We created what's called a message matrix, and it has these boxes. And in the morning, we go through all that. And what they do, and I give them hints, they're writing down in the boxes this information, all right? In the middle of it, it's the common agenda. What is your common agenda? Because the first thing we do right after lunch is we name the stakeholder group, and we help them decide how they're going to govern that group as they move forward. And so the message matrix serves two purposes. Number one, internally, that will serve to provide, to train everyone out in the field. SROs, school administrators, the courts. Then it's the second reason it's used externally for the media. Okay, so we have sample media press releases that they can draw from and they can massage to send out. And in fact, we play for them all the different news outlets from around the country. Like last year, we got Las Vegas, Clark County up and going, and they did a great job getting it out to the media, getting the media there, and a lot of positive feedback. But you have to really prep for that, okay? And that's what the message matrix serves. So let me give you a role play. The journalist calls, gets the press release. Let's say calls the chief of police. Hey, chief, I got the press release, okay? Tell me about, why are you doing this? Well, before he gets on the phone, he's telling his secretary, bring out the message matrix. So he's answering those questions looking at the message matrix. Well, you know what journalists do. I'm going to call the superintendent, see if I can trip them up here. All right, calls the superintendent or the chief judge of the judicial circuit. Ask the same questions. By the time the journalist gets off the phone talking with all of them, he's scratching his or her head going, it sounded like they were all in the same room together when I called. And that's important that you're on the same page, okay? But that's an excellent question.
It's also, I think from what you said earlier, Kevin, that the memorandum of understanding, by everybody agreeing to the process, there's nobody for the journalist to quote in terms of pointing fingers, in terms of the heads of the other agencies. So we're not having the DA or the police or the different folks taking
Bob,
shots.
And I failed to mention, this is really the closer, okay? is that we show campaign literature of judges who it was judicially led or whatever the case may be, who have put it in their campaign reelection, okay, and to demonstrate how it actually becomes a force to get reelected based on the outcomes. Because it's really nice when you can say there's 64% fewer victims.
So other questions? We have at least time for one more. As badly as I've managed the time, I think I still left time for that. For police, prosecutor, or judge? If not, let me just sort of close by sort of reminding sort of all of us that the standards themselves provide a basis for doing the kind of work that you've heard from these panelists, that if you need a tool or you need arguments in court, certainly with your administrative judge, the chief of police, that we have ABA policy that can back up your request, and that this is powerful stuff. So thank you to all of you for making, I want to thank you for making the trip to San Francisco, but for making the trip all the way down here to the Hotel Nico this morning. And thanks to our panelists.
My hands are real cold, but I'm